Jai Shri Ram, legal terms. Mathadipati, Mathadipati as defined in this Wharton Law Dictionary, Pocket Law Dictionary, Wharton, uh, is the head of a spiritual fraternity. Head of a spiritual fraternity, and of virtue of his office, he has to perform the duties of a religious teacher. Mathadipati is a religious teacher and the head of a spiritual fraternity. A maxim. A maxim is an axiom, a general principle, a leading truth, so called. Reason to believe. Reason to believe does not simply mean a purely subjective satisfaction. The belief must be held in good faith. It cannot be merely a pretense. Reason to believe must be held in good faith. Reason to suspect. Reason to suspect the commission of an offense. So, reason to suspect means the sagacity, the wisdom of rationally inferring the commission of a cognizable offense based on the specific articulate facts mentioned in the FIR. Reasonable action. Reasonable action means which is an informed, intelligent, just-minded, civilized man would rationally favor. That is reasonable action. Reasonable cause of action. A reasonable cause of action means with some chances of success when only the allegations in the pleading are considered. Reasonable doubt. Reasonable doubt does not mean some light, airy, insubstantial doubt that may fit through the minds of any of us about almost anything at some time or the other. It does not mean a doubt begotten by sympathy out of reluctance to convict. It means a real doubt, a doubt founded upon reasons. Reasonable doubt is doubt founded upon reasons. So, when you study the holy books of the Abrahamic cults, you will find sufficient grounds for reasonable doubt, doubt founded upon reasons. Reasonable grounds, and then reasonable hypothesis. Reasonable hypothesis. A reasonable hypothesis: before a person can be convicted on the strength of circumstantial evidence, the circumstances in question must be satisfactorily established, and the proved circumstances must bring home the offense to the accused beyond reasonable doubt. Reasonable opportunity. Reasonable opportunity is whether in the given case the show cause notice issued to the delinquent gives him some time, and also gives him the opportunity to explain that the penalty proposed is too much, harsh or disproportionate to the nature of the charge. Reasonable restrictions. That means limitations imposed on a person in enjoyment of the right. This enjoyment of the right is not arbitrary or of an excessive nature, which is beyond what is required in the interests of the public. Reasonableness and in public interest. This clearly demonstrates that the requirements of reasonableness runs like a golden thread through the entire fabric of fundamental rights. And as several decisions of the court show, this concept of reasonableness finds its positive manifestation and expression in the lofty ideal of social and economic justice, which inspires and animates the directive principles. Reasonableness and in public interest. Being reasonably sure. Reasonableness of expectation. Remember, every expectation is a resentment waiting to happen. Reasons to believe. Rebut, contradict, reply or contradict, REBUT, rebut. Rebutting evidence. Rebutting evidence is that which is given by one party in a cause to explain, repel, counteract or disprove evidence produced by the other party. Rebutting evidence. Recanting. Recant means to withdraw or renounce formally or publicly. Withdraw publicly or renounce publicly.